obviously starts usually with an investigation. Depending on the type of crime, the investigation may be very short, meaning officer shows up, arrests whoever on the scene, and then writes a report. In other cases, particularly more serious cases, your murder, rape, that kind of thing, the investigation will often stretch over days or weeks or months or longer, depending on the circumstances. Once the investigation reaches a point where the investigator feels that they have probable cause for an arrest, typically what they'll do is go to the local magistrate judge, swear an affidavit as to the facts that create that probable cause, and then the magistrate will sign an arrest warrant. It's important to note here, I think, these cases really have sort of a momentum that they build up as they go along. And the further you get down the road, the more difficult it is to turn the ship or hit the brakes or, I've had cases, the sooner you can get in, the sooner the attorney can start to slow it down. I have had a case, at least one case, where I was able to get involved during the investigation phase, talk to the investigator, although admittedly they're usually very, guarded maybe, with defense attorneys. They're very cautious about what they'll say, but I'm thinking of one actually from this past year where the person was charged with accused of a very, very serious offense. The investigator was looking for DNA and claimed to have probable cause and was going to get a search warrant. I was able to get involved, contact the investigator, go up the chain a little bit, point out that they in fact did not have probable cause, and get that all quashed and actually get the case suffocated before it ever got moving. But after investigation comes the arrest warrants. At that point, law enforcement is looking for you. If they have a way to contact you, oftentimes they'll call you, ask you to come in and turn yourself in, and usually around this point they want to speak to you if they have not already. Try and see if they can get any more evidence out of you, get you to say things that contradict yourself. It is, at least on the books, it's a crime to lie to law enforcement in an investigation, but it is not a crime for them to lie to you. And they will do that if it benefits their case or if it can get you to say something that will hurt yourself. If you have not obtained an attorney by this point, if you're getting a call to come turn yourself in, you definitely need to. So then you turn yourself in. You'll get served a copy of the arrest warrants. The arrest warrants, of course, contain that affidavit from law enforcement describing what they believe you've done. And then a case number and judge assignment will be made with the clerk of court. And if it's a misdemeanor, usually it'll be either with your local municipal court or with state court. If it's a felony, then it will be with the superior court of that county where the crime is alleged to have occurred. If there are warrants, as I may have mentioned already, you can be arrested without a warrant if something happens, in front of law enforcement. But if you're arrested with a warrant, you're entitled to what's called a first appearance within 72 hours. If you're arrested without a warrant, then you're entitled within 48 hours. First appearance is just the magistrate comes in, tells you what you're charged with, makes you aware of your rights, and then they're supposed to set a bond if they can, or at least consider bond if it's one of the charges that is within their purview. That is, it's not murder, not rape, or the 11 or so other most serious charges. Then they're actually supposed to consider and set bond if appropriate. Bullitt County, our magistrate, does not set bond in any felony cases. So if bond is set, then you bond out. If not, then your attorney, who hopefully you've retained by this point, can file their entry into your new case, and with that, typically a motion for bond and what's called a preliminary hearing oftentimes. So if you were not granted bond at that first appearance, then the next thing would be the bond hearing and the prelim. Preliminary hearing is just where the lawyer challenges the probable cause for the arrest. It's an opportunity for the defense and the prosecution to speak to one another, and also the prosecution will typically actually have the officer testify as to what happened. And so that actually gives a lot of clarity to the defense attorney and the client oftentimes, because sometimes they're not sure what has gotten them in this situation. After bond and prelim comes arraignment. Arraignment is mostly a formality. By the time I go to arraignment, I've already seen the indictment, read it, probably researched it if need be. What's important about arraignment is that it starts the deadline for filing any sorts of motions. That includes discovery motions, defensive motions, your motion to suppress, any constitutional arguments you've got, any defects in your indictment. You've got to get that filed. By default, it's 10 days. So 10 days after arraignment, all of your motions need to be filed. Most places, though, now the judge will extend that to about 30 days, but not everywhere. Again, that's something your attorney would be on top of. I usually, as soon as I'm in, and as soon as the case is indicted, I go ahead and file my motions. So when I show up at arraignment, I try to have all of my motions already filed. Discovery, of course, is the most important motion, because your motion for discovery is what demands that they turn over the evidence against you. One hearing I didn't mention that would have taken place before this is a grand jury. I don't mention that because in almost all circumstances, the defendant is not entitled to be there. It's just the grand jurors and the prosecution. And then they determine whether they're going to grant the state's request for an indictment. So after arraignment, usually not a lot happens in court for a while. The state has to get all their discovery together, turn that over, and then the defense has to review the discovery and do their own investigating. But usually after, I'd say, a period of a few months, the next thing that will come up in most places is what's called a plea day, followed by what's called a calendar call. Practically speaking, the purpose of these is just to kind of get everybody together, the prosecutor, the defense attorney, the defendant, and the judge, and let's talk about the case. are we going to have a jury trial, or is this something we can work out? And so most judges will have a plea day first, and then a couple of weeks later they'll have what's called a calendar call. Some judges go straight to calendar call. If you do not resolve your case and enter a plea, by that point, then you'll be put on the jury selection date. In most places, that's anywhere from the day after calendar call to about a week after calendar call. Jury selection is just what it's called. They bring in a panel of jurors. For each case, you've usually got 40 to 50. The prosecution and the defendant and defense counsel go through and strike jurors until they're left with 12 that will ultimately hear the case, and the case is put down for trial. Sometimes trial is the next thing. Sometimes you'll have a pretrial hearing, so if there are any outstanding motions, basically kind of like a cleanup. If there's any motions in limine, motions to suppress, or anything that the court has not addressed, they'll address it. Oftentimes it's the morning of trial. And then after that, it's the jury trial. So you put on the trial. If you're found not guilty, then that ends it. If the defendant is found guilty, the next thing would be sentencing. Again, this varies from judge to judge. Sometimes sentencing is immediately after the trial, as in the jurors enter their verdict, they're dismissed, and then the judge says, okay, well, now we're doing sentencing. Sometimes they'll say, okay, we're going to recess and we'll return next week and we'll do the sentencing. But that's start to finish. That's your timeline for a criminal case.